Honourable Youth Team. Yes, Minister of Labour.
Madam Speaker, allow me first of all to congratulate the Attorney General for bringing this piece of legislation and to wish him a prompt recovery. And I thank the Honourable Shakil Mohammed for having done his second reading and explaining the object of this bill and how it is going to improve the current legislation. Before I will deal with my speech proper, I would like to start by clearing a misunderstanding. The Honourable Leader of Opposition spent most of his speech criticizing the bill on the basis that apparently we are taking away the power of the President. And I don't blame him for that because he's not a lawyer. Because if he was a lawyer, he would have known that Section 64, subsection 1 of the Constitution clearly provides, and I read, Madam Speaker, in the exercise of his function under this Constitution or any other law, the President shall act in accordance with the advice of Cabinet or of a minister acting under the general authority of Cabinet, except in cases where he is required by this Constitution to act in accordance with the advice of or after consultation with any person or authority other than Cabinet or in his own deliberate judgment. So Section 64(1) of the Constitution lays down the residual rule. If the Constitution does not require the President to act in his own deliberate judgment, if the Constitution does not require the President to act upon the advice of a person, if the Constitution does not require the President to act after consultation with a person, the default provision is that the President has to act on the advice of Cabinet. The Honourable Member will recall the former President of the Republic, Mrs. Amina Garib Fakim, who tried to set up a commission of inquiry on her own to investigate the Sobrinos saga. What did his government, of which he was a part, do? They set up their own commission of inquiry, chaired by the former Chief Justice, Honourable Mr. Konai. And what did this commission of inquiry say in relation to the power of the President to institute a commission of inquiry? I quote, it's in paragraph 8.2 of the report of the Commission of Inquiry. It is beyond dispute that Mrs. Garib Fakim also violated Section 64(1) of the Constitution when she set up, pursuant to Section 2(2), the Commission of Inquiry. In the case, more recently, in the case of Bunjan and His Excellency the President of the Republic of Mauritius, same issue arose. And this is what the Supreme Court says. With regard to the facts of the present case, the Edberg decision is one taken by respondent number 1, the President, acting on the advice of Cabinet in accordance with Section 2(2) of the Commission of Inquiry Act. Therefore, such a decision is not one taken in his own deliberate judgment. It is clear. The President does not have any power on his own to institute any commission of inquiry under the existing legislation. So we're not taking anything which he doesn't have. In fact, we're simplifying things to avoid any confusion in the mind of a president like Honorable Farking, who might have thought that she had powers which she did not have. Now it is clear, the Prime Minister, because previously it was always going to be Cabinet who decide, now the Prime Minister, and I'm sure the Prime Minister, he will consult members of his Cabinet before he decides whatever he wants to do under the Commission of Inquiry Act. So we're not taking any power of the President of the Republic, Madam Speaker. The other confusion raised by the Honourable Leader of the Opposition is, according to him, there seems to be an inconsistency in the bill between Section 32 and Section 3. Section 32 provides any Commission of Inquiry issued under the Repeal Commission of Inquiry Act and which is pending on the commencement of this Act shall lapse. And then Section 3, subsection 3, says no Board of Inquiry shall be discontinued by reason of or otherwise affected by the Prime Minister's absence or by him ceasing to hold office, whether as a result of his death or for any other reason. There's no inconsistency at all. Section 3, subsection 3 is now an enabling provision which says that even if the person who appointed the Commissioner of Board of Inquiry now is no longer in office, that has no impact on the Board of Inquiry. And it was already the case under the existing law. If there was a change in the President, that would not have affected the working of the Commission of Inquiry. Now coming to Section 32. To my knowledge, Madam Speaker, there is only one Commission of Inquiry which is still pending. And it relates to the circumstances under which the contract was awarded by the contract of transport of petroleum products was awarded to Betamax. This issue, Madam Speaker, has been the subject of numerous PQs and PNQs in this House. Let me just remind honourable members two things. On the issue of whether the SCC, whether the contract was awarded in breach of Public Procurement Act. In answer to the PNQ, the Honourable Minister of Commerce stated, and I quote, "Mr. Speaker, sir, the contract was awarded after STC was exempted from the Public Procurement Act, and I think, as a lawyer, the honourable member should know." As a lawyer, he should have known that there was exemption. Then in answer to one of my PQs in 2011, the same minister stated, I asked about whether they had received legal advice before signing the contract. The honourable minister stated, "In fact, Mr. Deputy Speaker, sir, the advice of SLO was that the agreement is legally in order." And may I remind the Honourable Leader of Opposition, the minister who was answering was Honourable Shaukat Ali Sudan, president of the MSM party. So the MSM himself, minister, was saying that the contract is valid and we receive legal advice. He was Vice Prime Minister, but at that time he was only minister. But what did they do? After they came into power in 2014, they decided to stop the contract. What did Betamax do? Betamax went to arbitration in Singapore. What did the arbitrator say in Singapore? The arbitrator said, "I have construed all the Public Procurement Act and regulations, and SCC was exempted from the provisions of procurement legislation in respect of the contract awarded to Betamax." Now, SCC was not happy with this arbitration. They went to the Supreme Court in Mauritius. The Supreme Court said that it was against public order. So Betamax went to our highest court, Madam Speaker, which is the Privy Council. And the Privy Council, in a very elaborate, detailed, 41 pages decision, concluded, and I quote, the first issue was the Supreme Court was wrong. The first thing the Privy Council said, the Supreme Court was wrong in reviewing the decision of the arbitrator because the arbitrator's decision was final. But nonetheless, the Privy Council went on and considered the merit, and he said the arbitrator reached the right conclusion And the arbitral award was, in the arbitral award, on the exemption of the contract, and reached the conclusion that it was not illegal. So now you have what has been said in this parliament, that the contract was valid after receiving advice. What has been said in Singapore in the arbitration, the arbitrator said that it was valid. What was said in Privy Council, that the contract was not illegal, it was exempt from the provision of the Procurement Act, and it was valid. Now, after all these matters have already been settled, the government decide to put in a commission of inquiry? Isn't that a contempt of court? Isn't that showing disrespect for the decision of the highest court of our land? And how can he justify that it is in the public interest? How can he justify that it is in accordance, it is for the benefit of the people? The only thing that it means is harassing. It was the only purpose, and I'm saying it here, loud and clear, the only purpose of this commission inquiry was to harass who is now the Prime Minister of this country. So what we should do? Continue to allow wastage of public funds? Continue to allow a judge to come and question people over matters that has already been finally determined? There's nothing which the Commission of Inquiry can do today to reverse what has been said and determined by the Privy Council. Wastage of public funds. But what is important, Madam Speaker, what is important? It is that in answer to a PQ on 13 July 2021, the Honourable Minister of Commerce informed the House that the STC has paid 5.58 billion rupees in damages for legal and arbitration costs. And on top of this 5.5 billion rupees, they had to pay 153 million rupees only in legal fees, plus 75 million rupees for Betamax fees. So we're talking about 6 billion rupees of wasted funds. If we had these 6 billion rupees, no doubt we would be able to reduce the price of petroleum products in this country. What we're doing today, Madam Speaker, is precisely to avoid any government, not this government, any government who comes to power, try to use the Commission of Inquiry to harass political opponents. And today, the definition of the circumstances under which a Commission of Inquiry can be held is extremely wide under the existing Section 2 of the Commission of Inquiry Act. Why it is wide? Because when the law was passed in 1944, I have read the Hansard, at that time there was 5 ordinances which was dealing with the issue of a Commission of Inquiry. We're talking about pre-independence. After the independence, we had the Constitution. So, for example, what a Commission of Inquiry could do in terms of management, of looking into the management of governing bodies, public bodies, looking into the conduct of a public officer, that has been taken over by statutory creatures. For example, the ombudsperson under Section 96 and 97 of the Constitution, the ombudsperson has the power to investigate any action taken by any officer in the authority. Similarly, under Section 110 of the Constitution, the Director of Audit, he audits all the public accounts, and in doing so, he investigates the conduct and management of any department or any public service. The Public Accounts Committee also scrutinizes how public funds are spent. So we don't need a Commission of Inquiry today to investigate the conduct and management of a department or to investigate public officers. We still need, in certain cases, to have a board of inquiry. For example, where something has happened and there is a public concern. I'll give you an example. For example, what happened in Wakasho. Up to now, we still are not sure what happened in Wakasho. What happened during COVID? How decisions were taken no proof, no paper. We only know that billions of rupees were sunk. What happened to the patients? What happened? These are things which there is a real public concern, and public want to know the truth. And here, what we can give assurance to this House and the population, Madam Speaker, is with this government, there will never be any cover-up. Whenever we need, we will govern in transparency. And when you look through this new bill, there's a number of ways where we're making this board of inquiry more transparent. The appointment. The Prime Minister, he doesn't in catimini go and negotiate with the Commissioner and settle their fees. He comes to Parliament. He makes a statement. He gives the terms of reference. And after he gives that, all the hearings are done in public. Only exceptionally, the president of the board can decide not to allow public presence. And once the report is completed on the set date, the board gives the report to the Prime Minister, and the Prime Minister has 30 days to lay a copy of the report of the Commission of the Board of Inquiry in Parliament. So members of Parliament will have a copy. It will be in the public domain. Any question can be asked by members of the Parliament. This is what we want, transparency. That was not there in the existing Commissions of Inquiries Act. That is why we're changing it. Under the existing Commission of Inquiry Act, you didn't have a time frame. You can have, Commission of Inquiries going on for years and years. For example, the Commission of Inquiry to look into the sale of the shares which BAI company held in Britain. This was set up, Madam Speaker, in May 2017. But when was the report published? In June 2021, 4 years later. No doubt because one of the members, and I'll come to him shortly, one of the members was busy with other lucrative assignments. But now with this bill, there is a timeline set. The Commission of Inquiry cannot go beyond this. If we give them 1 month, 1 year, they have to abide by this time frame. Costs. This morning, during PMQT time, the Prime Minister shocked the whole world, the whole population, this House at least. You can tell the world, because I don't think in the entire world we've seen someone who is part-time. He's a part-timer, and he earns 286 million rupees as a part-timer. And he came and sat on that committee for Commission of Inquiry and got 2.2 million rupees. Now the Prime Minister is going, under this bill, is going to publicize. The amount is going to come from the consolidated fund. So there will be transparency. Everybody will know how much money is paid to commissioners. Everybody can ask questions. The other novelty, conflict of interest. I'm sorry, I'm going back again to the Honourable Gentleman, Mr. Sattar Haji Abdullah. Mr. Sattar Haji Abdullah was handpicked by the former Prime Minister, because the Prime Minister is the one who gave advice to the President to make him an assessor. Who was Mr. Sattar Haji Abdullah? He was asked as a commissioner to determine whether the sales by BAI company of its shares in Britain, Kenya, was done in a fair manner. We got value for it. But who was Mr. Haji Abdullah? He was the administrator of BAI. He was the administrator of BAI. He's asking people to inquire. He's going to inquire on himself. But above this, who was he? He was the special envoy of the Prime Minister, who went, the boss, because they all heard the recording. He went and he asked Daud Rawat to sell his empire for 1 rupee. How can you be so conflicted? And yet, these were the type of people which the old regime will handpick to do commission of inquiry because it was always politically motivated. They always wanted the commission of inquiry to give the result that they wanted to hear. With this bill, no. With this bill now, the commission of inquiry, any members of the board will have to make clear that they don't have any conflict of interest. It's in section 8, subsection 2. No direct interest in the matters under inquiry, and no close association with any interested party. Madam Speaker, before resuming my seat, allow me to say just a few words briefly on what I consider to be the most important provision of this bill. And this is as a result of a long series of judicial pronouncements. It is in section 18 of the bill, persons likely to be prejudicially affected to be heard. Now, what happens in practice under the existing commission of inquiry? The commissioners hear a lot of people, and then they publicize their report. And when they publicize their report, very often they make comments. Some of the comments are very hurtful, very unwarranted. And then the people who feel aggrieved, they have to go to the Supreme Court, sometimes to the Privy Council, only to be told that the Commission of Inquiry ought not to have put certain comments about their conduct without having given them the chance to be heard. So today, in this section 18, if at any point during inquiry, the Board of Inquiry is of the view that a person's reputation could be prejudicially affected, that individual must be given a reasonable opportunity to be heard. To use the wording of the law lords in the Privy Council case of Kumara and Payendi against Paul Lamshanding and others, I quote, a person must be given a fair opportunity to worthwhile evidence and make representation on his own behalf. It's an elementary rule of fairness and natural justice. And to make it clear, I give you an example so that everybody understands what I'm talking about. If during a commission of inquiry on drugs, you have a notorious drug trafficker, Perumal Veren, come and say that the leader of a leading political party is financing the import of drugs, then that person should now, under this act, has the right to be heard and clear his name. Under the existing law, they didn't have this option. So, Madam Speaker, really, this is a big avancée today, this bill. It represents a profound reform, offering our country a new modern legal framework with the necessary checks and balances to ensure transparency, fairness, and impartiality in investigation of matters of public concern. Thank you.
Thank you, Minister. Yes, Honorable Ramdas.
Merci, Madame la Présidente. Madame la Présidente, d'abord, permettez-moi de féliciter l'honorable Attorney General ainsi que le ministre des Terres et du Logement pour avoir tenu notre promesse électorale.
But acting Attorney General.
The Honorable Acting Attorney General, no, the Honorable Attorney General and the Honorable Minister des Terres et du Logement, and also Acting Attorney General, indeed, pour avoir tenu notre promesse électorale et présenter devant cette auguste Assemblée, seulement 6 mois après notre élection, ce projet de loi. Un projet de loi, Madame la Présidente, qui a pour but, entre autres, de restaurer un climat de responsabilité et de restaurer un climat de transparence dans la gestion des fonds publics. Et cela, Madame la Présidente, à la lumière des excès de l'Ancien Régime. L'Ancien Régime qui n'a pas manqué de subtiliser une loi prédatant notre indépendance pour véhiculer un agenda éminemment politique. Madam Speaker, it is indeed remarkable, if not concerning, that for more than 80 years now, the Commission of Inquiry Act of 1944 has remained the main legal mechanism for investigating matters of public concern. This act, Madam Speaker, in fact the Commission of Inquiry Act 1944, conceived during the colonial era, reflects a time when Mauritius had yet to emerge as a sovereign democracy. And as our society evolves, Madam Speaker, our norms do evolve as well. Our values evolve as well. Our expectations evolve as well. And the law, Madam Speaker, makes no exception and ought to evolve with it as well. And the legal framework, Madam Speaker, cannot remain static while the society which it is meant to serve keeps on advancing. Donc it is a clear, in fact, the presentation of this public inquiries bill, Madam Speaker, is therefore not only timely, but also a necessity. And in fact, it is a clear reaffirmation of our national commitment to transparency, accountability, and good governance. Madam Speaker, in respect of the prescribed time frame, the time frame prescribed under the bill, we must be candid, Madam Speaker. Mauritius has for far too long witnessed commissions of inquiry that have undermined the perceptions of that has in fact been undermined by perceptions of political motives, excessive delays, and in fact outright suppressions of findings, Madam Speaker. Some inquiries, Madam Speaker, have been extended for years without any conclusive outcome. In fact, others have simply been discontinued without any explanation whatsoever. And in fact, Madam Speaker, je me réjouis particulièrement du fait que sous les clauses 4 et 7 du présent projet de loi, les terms of reference du Board of Inquiry institués par le Premier ministre peuvent maintenant préciser, comme l'a dit l'honorable ministre du Travail avant moi, les terms of reference institués par le Premier ministre peuvent maintenant préciser la date à laquelle le Inquiry Report sera soumis, tout en offrant bien évidemment la possibilité à l'honorable Premier ministre de modifier ces terms of reference, en offrant la possibilité de modifier, comme je le dis, dans l'intérêt public, quand l'intérêt public le requiert, ce qui suppose donc la possibilité d'étendre l'échéance de l'enquête en question pour des motifs justifiables. And the Public Inquiries Bill, Madam Speaker, therefore introduces greater discipline into this process. It delineates responsibility, and it clearly places appropriate limits on the political discretion. And in fact, this novel provision, Madam Speaker, has the merit of striking on the one hand the right balance on the one hand between the executive authority and on the other hand public accountability, and in fact a hallmark to any robust democracy. Madam Speaker, in respect of the holding of proceedings in public, clauses 13 and 14, for example, establish the presumption that inquiry proceedings will be conducted in public. Those who have spoken before me have spoken lengthily about it, and in fact it sets out the presumption that inquiry, as I said, will be conducted in public unless, of course, valid exceptions apply. And this move towards openness, Madam Speaker, enhances the public trust and ensures that justice is not only done but also seen to be done, Madam Speaker. And the provisions for public notices and the possibility of public engagement strengthens, in fact, this transparency further. And in fact, moving us decisively away from the secretive manner in which inquiries were conducted in the past. And I'm making reference here to the past 10 years during which this country was led by the MSM. Madam Speaker, in respect to the provisions for reports to be made public, in fact, in a much welcome move, clauses 21 and 22 of the bill provides firstly for the mandatory tabling of the inquiry report before the National Assembly, and secondly, for the mandatory publication of every report of every Board of Inquiry in the official government gazette, thus allowing for publicity. And I must say, Madam Speaker, that under the old Commission of Inquiry Act 1944, there was no obligation whatsoever on the Commission of Inquiry to publish its report. Neither was there any obligation on the President of the Republic to cause any such report to be published. And this, in fact, in my very humble view, Madam Speaker, this went against the very nature. It went against the very nature of such inquiries which are meant to address issues of public concern, of public interest, and of public welfare, and which are conducted using public funds. And, Madam Speaker, in fact, this bill addresses the issue, it addresses this very issue in a very straightforward manner. in a very straightforward manner, leaving no possibility whatsoever for any derogation from the principle that every inquiry report must be released to the public through publication in the Government Gazette, hence leaving absolutely no room whatsoever for any opacity and lack of accountability. And this is precisely what this government wishes to promote, Madam Speaker. Now, in respect of the delay to ask for a review, Madam Speaker, it is noteworthy that clause 30 of the bill reduces the delay for the institution of judicial review proceedings against any finding of the inquiry from the usual 3 months under common law to now 21 days. And this delay of 21 days, Madam Speaker, starts to run from the date of the publication of the inquiry report in the Government Gazette. And this is yet, Madam Speaker, in my very humble view, yet another move to show the government's intention to reach finality, and to reach finality within the shortest possible delay. Now, in fact, the Honourable Minister of Labour has spoken about this before me in respect of the persons who are likely to be prejudiced when their names are cited before the Commission of Inquiry. This bill, Madam Speaker, upholds the rights of witnesses, and it is a very good thing that it does. In fact, clause 16 of the bill guarantees the right to legal representation. And we will note that clause 18 of the bill guarantees the right to respond to evidence presented before the inquiry. And this, in fact, represents, Madam Speaker, a significant step. It represents a significant step forward in ensuring procedural fairness and protecting individuals from reputational harm based on unchecked allegations. In fact, the Honourable Minister of Housing and Lands has set out a series of pronunciations, a series of judgments delivered by the Supreme Court of Mauritius in respect of the necessity of those whose names have been cited to be given the opportunity to defend themselves. Et je dois dire, Madame la Présidente, qu'en tant qu'avocat, j'accueille favorablement cette clause 18 du projet de loi qui requiert du Board of Inquiry, qu'un Board of Inquiry, en fait, permette à tout individu dont la réputation pourrait être impactée par l'exercice d'être auditionné par le Board et de soumettre des éléments de preuve pour se défendre. Et soulignons par ailleurs, Madame la Présidente, que le droit de donner sa version, afin de se protéger, de protéger sa réputation, était toujours le droit commun de tout individu. Mais ce projet de loi, Madame la Présidente, la clause 18 de ce projet de loi entérine ce droit de façon la plus claire, de manière à ne plus laisser d'incertitude quant à son application aux commissions d'enquête. Et cette provision, Madame la Présidente, permet de faire une balance d'une part entre les attentes du public à un processus transparent et d'autre part le droit de chaque individu à la protection de son image, de son intégrité, de sa réputation. Madame la Présidente, nous nous rappelons tous de la commission d'enquête qui avait été instituée par le régime MSM, par le gouvernement MSM sur la drogue. L'institution d'une commission d'enquête qui avait pour but tout, mais vraiment tout, sauf combattre le fléau de la drogue. Le fléau de la drogue qui gangrénait et qui gangrène toujours notre société, Madame la Présidente. Une commission d'enquête qui avait été instituée par le MSM à des fins bassement politiques, afin de marquer des points politiques, sans la moindre vision pour les jeunes de ce pays. Madame la Présidente, nous sommes tous ici politiciens. Nous faisons tous de la politique, probablement à l'exception de vous-même. Et nous souhaitons tous être réélus. Nous souhaitons tous être réélus. C'est un petit peu le souhait de tous, bien évidemment, si nous sommes confiés d'une nouvelle investiture pour les prochaines élections. Nous souhaitons tous d'être réélus, Madame la Présidente, mais pas à n'importe quel prix. De ce côté de la Chambre, Madame la Présidente, contrairement au précédent régime, nous sommes résolument contre l'idée de voter des lois dans le but uniquement de satisfaire un agenda politique. Bien au contraire, Madame la Présidente, nous sommes plutôt pour une législation qui cadre avec la vision de ce gouvernement, une législation qui cadre avec les attentes de cette population et surtout celle de la nouvelle génération. Donc, en guise de conclusion, Madame la Présidente, je dirais ceci. This bill is not merely a legislative reform. It is a statement of our values, a signal to the people of this country that the institutions of our democracy are being modernized to meet contemporary standards of justice and integrity. The Commission of Inquiry Act 1944, Madam Speaker, belongs to a bygone era. The present bill, in fact, reflects the Mauritius we have become. It reflects the democratic future we are striving to build for this country. So let us seize this opportunity, Madam Speaker, to turn the page on outdated colonial frameworks. Let us embrace a new legal structure, a new legal architecture that strengthens democracy, transparency, that protects our rights, and especially that it reinforces public trust. So the enactment of this bill, Madam Speaker, is not simply beneficial, it's a necessity. So I therefore fully support this bill. I thank you. Merci.
Thank you. Honourable Nassingel.
Thank you, Madam Speaker, for giving me the floor. In fact, before starting with my speech, I would like to make some comments on the speech of the leader of the opposition. J'étais en fait très surpris par le discours du leader de l'opposition. En fait, un tiers de son discours était axé sur les pouvoirs du président de la République et malheureusement, un tiers de son discours il a complètement passé à côté de la plaque. Un tiers de son discours était axé sur une sorte de démagogie. J'attendais mieux de lui pour venir avec des suggestions beaucoup plus intéressantes. Malheureusement, je suis resté sur ma faim. Et un tiers aussi de son discours, malheureusement, il a parlé dans la généralité sans venir avec des dispositions concrètes de la nouvelle loi. Now, here again, Madam the Speaker, once again, government is coming with a new bill, and as mentioned by the Acting Attorney General, it is not a mere cosmetic change. And you will see, Madam Speaker, in a span of 6 months, in an unprecedented manner, government has come up with a string of legislations to consolidate democracy, human rights, transparency, accountability, equity, and above all, good governance. Never in parliamentarian history have we witnessed with such a zeal to reposition Mauritius as a cradle of democracy and good governance. In fact, Madam the Speaker, we want to regain our prime position in Africa, in the whole world, regarding accountability and transparency. In fact, accountability and transparency are subsets of democracy and good governance. We want Mauritius to be Mauritius, not a banana republic, as it has been for the past 10 years. What are the expectations in a modern society? It is high time to repeal a law outdated, dating from 1944. The Commission of Inquiry Act cannot respond to the needs of a modern society where transparency and accountability have become supra-constitutional concepts. As you know, Madam Speaker, as a seasoned barrister, you know, for example, separation of powers is not clearly stipulated in the Constitution, but it is underlying. Likewise, in modern constitutions, transparency and accountability and good governance are underlying constitutional principles. They form part of the architecture of the Constitution of Mauritius, not only in Mauritius, but in most of the countries championing good governance. We have witnessed recently, for the past 10 years, a sort of instrumentalization of Commission of Inquiry to target political opponents. And we have seen also over-politicization of this important tool to promote accountability and transparency into a lethal political weapon. We must understand the rationale behind the previous law and also the new law. First and foremost, it is meant to seek the approximate truth when there is a matter of public importance, focusing on public interest. This is what, unfortunately, the leader of the opposition has not been able to understand. He is referring to subjective interests. In fact, when we are using this concept of public interest, this brings more objectivity. And the Prime Minister will have to base himself on public interest before triggering any board of inquiry. and also take into consideration national interests as opposed to mere petty political interests and partisan interests and subjective interests. The change from a Commission of Inquiry Act to a Public Inquiry Bill is not a mere change of title. It is a paradigm shift. It is not just a change of title as name, but it lays emphasis on public interest. Now, regarding targeting of political opponents, I will take only two recent examples. The previous government, as you know, Madam Speaker, had a sort of compulsive obsession to finish off, annihilate the actual Prime Minister, who will not remember, as alluded to by the Minister of Labour, the case of Betamax. Who will not remember that case? The international arbitrator came to confirm that there was nothing wrong with the allocation of contract. Yet the previous government appealed against the decision at the level of the Supreme Court. The latter reversed the decision of the arbitrators. The matter went to the Judicial Committee of the Privy Council, and in a blockbuster decision, the Judicial Committee of the Privy Council gave a sort of slap to the previous government and incidentally also to the reasoning of the then Chief Justice. Surprisingly, even after the slap of the Judicial Committee of the Privy Council, government dared to set up a commission of inquiry on the whole matter. This capricious and vicious decision was not only a pathological obsession against Dr. Navid Ramgoolam, but also, I want to lay emphasis also an attack, direct attack on the Judicial Committee of the Privy Council, incredible but true with the previous regime. The second example, it's good to take that second example, is how the previous Prime Minister tried to settle score with the previous President of the Republic, Mrs. Garib Amina. Here also, it is also good to underscore the confusion regarding the powers to set up a commission of inquiry. Regarding the commission of inquiry, you cannot look at it in isolation. And this is a mistake done by the leader of the opposition. In fact, you have to read the Commission of Inquiry Act along with Section 64, subsection 1 of the Constitution, as explained clearly by the Minister of Labour. In fact, it must be read in conjunction. In a nutshell, only in a few instances, the President can act, the leader of the opposition has to listen carefully, has to act in his own deliberate judgment, and also after consultation. In other circumstances, the President is bound to act under the advice of Cabinet or the Prime Minister or other authorities. The present bill comes to cure a sort of confusion, in fact, and designate the Prime Minister as the sole authority to appoint a public inquiry. On the soberness scandal, we were on the verge of a constitutional crisis. The leader of the opposition was referring to the supposedly crisis in 2002. But we were on the verge of a crisis because there was confusion. And this bill this time is trying to remedy this confusion which existed under the previous law. This is very important. And why did I take the second example? This is to show, just as in the case of Mr. Kisnan, late Mr. Kisnan, haunting the MSM, how they can instrumentalize, weaponize certain tools to kill their own people. And this is very sad. Now let me, Madam Speaker, take some concrete examples to show how this present bill is an improvement when we compare it with the Commission of Inquiry Act. First, you will see Section 3 clearly defines public interest, whereas before this was not defined. Now, concerning Section 10 to 12, we are going to see there are certain procedural safeguards, and the 2025 bill this time offers stronger rights and protection for participants, including fairness and transparency throughout the inquiry process. Now, regarding judicial review, in fact, it was possible under the purview of the previous law to have a judicial review, but this time, under the new law, empire of the new law, this is explicit that people within a span of 21 days can have recourse to judicial review. So, regarding the terms of reference, before the terms of reference, Madam the Speaker, were being dictated only by the Prime Minister, whereas this time, regarding the terms of reference, this can be discussed, the Prime Minister can discuss with the chairperson who will be appointed, and then decide on the terms of reference. So definitely, Madam the Speaker, there are a number of improvements in the present bill, and one last point. There is a very good point, very, very important, interesting point which has been included in the new bill. That is, the Commission of Inquiry is being equipped with more tools. That is, the bank will have to make a disclosure. I don't know now whether the leader of the opposition is afraid, is scared. So many scandals by the previous government that is a bit scared that we can open the Pandoran box. This is very unfortunate. And so the leader of the opposition can rest assured that this government means business. The Prime Minister is a responsible person. People who are going to be appointed for future commissions of inquiry are going to do their job. We are not going to do la chasse aux sorcières like they did in the past, for sure. You can rest assured, Mr. the Leader of the Opposition. Thank you.
You were trying to raise a point of order, Mr. Duval?
I was only drawing your attention to the fact that he was imputing motives, which is not
Yes,
proper.
but you can't do that by sitting down
Yes.
and talking to me as if we're in a sitting room somewhere. You have to stand up and make your point of order. Now you have the floor.
Thank you, Madam Speaker. Madam Speaker, first of all, laissez-moi dire qu'il est regrettable de constater que l'opposition recule ici sur l'ordre des orateurs, que autrefois était coutume qu'on puisse parler à la fin, clôture le débat, et le changement qui a été promis n'est pas celui qui a été apporté, et on se réfère aujourd'hui sur les mauvaises pratiques, alors que ici même, moi-même j'ai eu l'occasion de parler avant le Premier ministre, parce qu'il est la coutume de pouvoir clôturer les débats pour l'opposition. Mais il est regrettable de constater. Madame la Présidente.
I want to inform honourable members that the Leader of the Opposition and Mr. Duval came to see me and asked me if it was possible for Mr. Duval to speak before Honourable Minister Soubron. I took time. After, I'm sorry. After. No, he asked for after. He's right on that. I took time and I went and found out what the practice has been, and it seems from what I gathered, I was not here, it seems from what I gathered that in the past there has been no such practice, but on the contrary, what some people are saying here, but on the contrary I learned that many members of government were speaking last and not what. Okay. Don't shout while I'm talking. Don't shout while I'm talking. Do not fight each other while I'm on my feet. Okay, so I took this and I spoke to the Honourable Duval at tea time, and I told him that he will have to speak before, as unfortunately, that is very important. I am not the one who decides. I want to make this clear. The whips are supposed to meet each other, and every time we will have this problem in the House, you better find out once and for more, it's not for the Speaker to decide. The whips must come to an agreement. If they don't come to an agreement, it's just too bad. I can't do any better. So now you have the floor. Please take the floor on the bill.
Thank you, Madam Speaker. I was indeed fourth until I protested. But tout le monde est libre de constater où est le changement.
No more comments.
Alors, Madame la Présidente, this bill is a step in the wrong direction. I will stress on that. Wrong direction, Madam Speaker. There are many good measures.
Let him speak. Let him speak.
Many good measures. I will start with the good measure and then I will dwell on why it is a step in the wrong direction. The good measures to bring it to Parliament, yes. This is what is expected in a democratic society. to bring commissions of inquiries which are in the hands of the Prime Minister be brought to be made public. Yes, that is one thing which is a good thing. There are other good things with this bill, Madam Speaker. That there is a right of appearance for those who are the subject of criticism or remarks by the Commission of Inquiry. Yes, that is also a good thing. Let us note that under the previous law, the Commission of Inquiry had the liberty to make its own rules and could allow for anyone to appear before it. And also, the other good thing about this law, before I start with the rest, is, Madam Speaker, for the time limit to be imposed upon setting the terms of reference, because commissions of inquiry have in the past been going on and on and on and on, and then the reports, it has happened, have again slept dans les fonds des tiroirs. So this is a good thing with the law. But, Madam Speaker, and this will be the thrust of my intervention, this could have been brought with amendments to the existing law. These could have been brought with amendment to the existing law. And those things that were not stipulated in the law but that were done in practice, for example, judicial review, were already well established. For example, contrary to what the Honourable Mr. Utima said, payment into consolidated fund, this is already provided in the existing law. But, Madam Speaker, it is a step in the wrong direction because we are now taking the power away from Cabinet, giving advice to the President, and giving it solely to the Prime Minister. Under the actual law, the President acts on the advice of Cabinet and appoints a commission. And all those issues that are determined by the President is done acting upon the advice of Cabinet. And my friend Honorable Utim is absolutely right when he quotes the section of the Constitution 28.1, which confers, sorry, not 28.1, 64.1, which confers, which narrows down, interprets the powers of the President when he acts on the advice of Cabinet, when he acts in his own deliberate judgment, etc., etc. And this has been, again, taken into great details by the recent Commission of Inquiry on the setting up of the Commission of Inquiry by the President. And, Madam Speaker, therefore, the Mauritian public has to understand that under the actual law, it is not merely the Prime Minister who decides that he wants to appoint him or that person, or that he wants the Commission of Inquiry to have such and such terms of reference, or that he wants eventually to amend the terms of reference, or that he wants, for example, to allow for the payment of fees or not. It is not simply the Prime Minister. It is a collective decision taken by Cabinet, deliberated upon by Cabinet, and then, upon the advice given to the President so thereafter effectively acts on this advice. But there are two layers which we are removing here. Two layers of control, if we can say. Inutile for some. The first layer, it is Cabinet collective responsibility, where the matter has to be decided upon, debated upon, and decided upon. And all those powers which we see in the Act now, which is now being given to the Prime Minister, used to be enjoyed by the President, acting on the advice of Cabinet. So that was the first layer. And then the second layer, of course, being the President himself. Because let us not forget, the President has a responsibility, a constitutional responsibility, according to Section 21B of the Constitution, he has the duty to uphold and defend the Constitution and to ensure that the institutions of democracy and the rule of law are protected, that the fundamental rights of all are respected, and that the unity of the diverse Mauritian nation is maintained and strengthened. So at all times, the President of the Republic must ensure that whatever he does is in accordance with Section 28(1)(b), and contrary to what the Honourable Utim said, it is not merely a rubber stamp decision, because we forget, he knows that better than anyone else, that the President may refuse and resign, sure, like his father did himself. But he may refuse. If he doesn't agree, he may refuse and thereafter resign in protestation. That is what we had under the actual law. But now what will we have? We will have a Prime Minister who will enjoy sole discretion to set up a commission of inquiry. As Prime Minister who will not have to consult Cabinet to appoint any member commissioner. A Prime Minister who can, and I say a Prime Minister because we're changing the law not for one Prime Minister, but for any Prime Minister. A Prime Minister who will be able to revoke any members of the Commission if they fall for any reason stated in the law, and some of these reasons are very vague, Madam Speaker, like the Leader of the Opposition has said. If you look at Section 9(3), the Prime Minister may at any time terminate the appointment of a member on the ground of a close association with an interested party, which is very vague. But then there are other issues, Madam Speaker. The fact, for example, that the Secretary to Cabinet appoints, Madam Speaker, the Secretary to Cabinet appoints the Secretary to the Commission. When we know the key sensitive function of a Secretary to a Commission, who holds all the documentations, all the evidence, who knows of the agenda of the Commission, who knows of all the intricate and fine details of where the inquiry is leading up to. And when you appoint the Secretary yourself, or through the Secretary to Cabinet, then il y a un risque d'interférence et d'influence énorme, Madame la Présidente. It didn't used to be like that. The President used to appoint the Secretary himself. Usually, over the law did not provide for it, but when you look at the various commissions that have been set up, you will see often it is headed by members of the judiciary and their secretaries, judicial secretaries, are appointed as Secretary to Commission. Therefore, it implies that before appointing, the President would consult with the Commission. And it ought to have been like that, Madam Speaker. Like the Honourable Shakil Mohammed has rightfully stated, that in New Zealand, in Canada, in Australia, he's quoted that there is a risk of political interference, that is the worst of the worst, to guarantee that a commission can do its job properly and function properly. He is right. But then we must look at what Canada, New Zealand, and Australia has done. Does the Prime Minister there have the power to appoint, to revoke, to withhold payment? No. It is done through the same mechanism that we have under the existing law. There, the governor in council in Canada, in New Zealand, in Australia, the equivalent of the President appoints. Governor in council being, of course, Cabinet, which decides, and then in Australia, for example, in New Zealand, in Canada, Cabinet does that, takes a decision, the same mechanism that is done here, virtually the same, not the Prime Minister. And there, Madam Speaker, it is not the Prime Minister's Secretary to Cabinet, the Secretary to Cabinet, who appoints members, including Secretary to Commissions there. They are given full autonomy and independence to appoint their own staff, their own advisors, their own secretaries, etc. And we ought, if we wanted to have given this institution proper independence. Well, forthcoming Board of Inquiry's proper independence, functioning independence, we ought to have at least consulted them with who to appoint. So that, Madam Speaker, is another reason why it is a step in the wrong direction. Because we need to ask ourselves, how is this new act going to facilitate shedding the truth, light on the truth? Are we doing that? When we know that in this House, time and time again, ministers, prime ministers, have so often relied on investigation. The Honourable Sikan has done that earlier on. Relied on investigations not to give information, not to give certain documents. We know how this House has seen so many, unfortunately, occurrences. So therefore, there are questions that arises. Given now that under this law there is no provision, for example, for parliamentary questions to be answered in Parliament on those subject matters, for example. The question must be begged, will the Prime Minister tomorrow, and I will state why, will the Prime Minister tomorrow undertake to answer questions on any investigations that are ongoing or that have been suspended, because there is provision to suspend here investigations with other investigations. So will the Prime Minister...
That are ongoing, you said? Investigations
or suspended, or suspended. So will any sort of information be provided on the subject? Or once an investigation is set up, will it be like it has in the past? Will it be simply a blanket to remove altogether the duty of Parliament to scrutinize, the power of Parliament to scrutinize? We all remember in the past, since the creation of ICAC and before that, how many investigations have slept in the drawers. But then when we give all the power and control to one person, do we really rid ourselves of those risks? And that is another question. So, Madam Speaker, the previous law was not flawless. Again, it could have been amended, but instead, we are throwing the baby out of the bathwater. We are doing away with the law. And the reasons being put forward by the Honourable Acting Attorney General is, amongst others, found in the institution on the Betamax Commission of Inquiry, that being a farce, etc., etc. But, Madam Speaker, I'm not going to go into the merit of a commission of inquiry which is ongoing, which is being led by a member of the judiciary, which has spent months, years, doing extensive work, and which must simply now accept the mandate of that commission to be repealed with this act without any sort of transitional provision allowing it to finish its work within some sort of time frame, without any chance of coming up with its report. And it is not true to say that the findings of the arbitral award of Betamax cover all the items under the terms of reference. I'm not going to make that case here, but I'm only replying to what has been made, to say that it is simply not true to say that because of the arbitral award and the findings of the arbitral court, that this commission of inquiry must simply be done away with in this manner. d'une manière irrespectueuse aux membres du judiciaire. And that is regretful, Madam Speaker. And I think that it should be allowed. It ought to have been allowed.
Let him speak, please.
It ought to have been allowed, like any other act which comes to repeal. It ought to be allowed, like any other, in any other bills which purpose to repeal a previous one, a transitional provision, and no section should have been made for that. And that, Madam Speaker, is regretful. And I will reply to the Honourable, and this is why it's important to speak when you're replying for the opposition, to be able to reply. This is why usually we want to reply at until the last possible intervener has done so. In reply to the Honourable Nassingen, he's mistaken. The terms of reference being decided solely by the Prime Minister is under this bill. The consultations being done prior by the Prime Minister with Cabinet, etc., was done under the existing law. But the terms of reference now being decided solely by the Prime Minister is under this bill. So he's mistaken when he's talking about un avancement dans ce sens. C'est tout le contraire, Madame la Présidente. Et je l'ai dit, donc, pour moi, nous reculons, Madame la Présidente. Il n'y a aucune raison qui a été mise de l'avant pour justifier la concentration du pouvoir autour des commissions d'enquête dans les mains du Premier ministre, alors que nous avons un mécanisme bien établi qui fonctionne dans tous les pays du Commonwealth de renom, le Canada, la Nouvelle-Zélande, l'Australie, ou, comme je l'ai expliqué, avec le cabinet, le Conseil des ministres, la décision collective, la responsabilité collective, avec le président de la République, qui lui aussi, à la fin de la journée, a le pouvoir de refuser, s'il le souhaite. Quitte à partir, ça rajoute quand même 2 couches de garantie. Donc, Madame la Présidente, Madame la Présidente,
You're concluding, of
yes,
course.
thank you. Madame la Présidente, I think for all the reasons that have been given, I think people will now fear to come and depone, more so than before. And I think, because do not forget that commissions of inquiry are usually in a democratic country set up to investigate acts and doings against the government of the day. But now that there is the risk of interference, as I said it, with the appointments of the secretary to the commission, etc., it will not at all, Madam Speaker, unfortunately, help our meager ranking in Transparency Mauritius. It will not help us improve, unfortunately. Not these sort of legislations. I think it is a step backward. I think it is in fact, Madam Speaker, regrettable that we couldn't change the existing law.
You've said that 3
And I
times.
think that, Madame la Présidente,
Try and conclude.
I am concluding. And I think, Madame la Présidente, le pays n'en sortira pas du tout gagnant. Merci.
Je vous prie. Je vous en prie. Alors, maintenant, j'ai l'honorable ministre de la Sécurité sociale.
Thank you, Madam Speaker. I will come back to the speech of the Leader of the Opposition and Honorable Duval later. First of all, let me say that this bill opens a window of change. This government brings yet another visionary tool to reshape public interest issues in Mauritius. The bill, the Public Inquiries Bill, which will replace the more than 80 years old Commission of Inquiry Act, heralds a significant shift on how matters of public interest and public importance will henceforth be investigated, for the benefit and betterment of the Mauritian society and its people. My party, Résistance et Alternative, as a partner in the Alliance du Changement, fully support this bill. A commission of inquiry is one of the many bodies available to a country to inquire into various public interest issues, sometimes on controversial ones. Commission or board of inquiry report findings, give advice, and make recommendations. While the findings are not legally binding, they can be highly influential and act as drivers of societal progress. Commission of inquiry reflect social movements and social concerns of a particular moment in time. Madam Speaker, Commission of Inquiry can be a great tool of social emancipation and progress. In Mauritius, social upheavals against the harsh exploitation under colonial capitalism produced two major colonial commissions of inquiry. The dialectics of social struggles and colonial commissions of inquiry laid the foundation of social progress in Mauritius. After the major upheavals, riots, strikes in various parts of Mauritius in 1937, which resulted in the killing of free laborers, the British colonial government instituted the Hooper Commission of Inquiry. The Hooper Commission lifted the ban on workers to organize and gave birth to the right for the workers of Mauritius to unionize in 1938. The 1943 strike of laborers, when Angelique Coupen and her comrades lost their lives, prompted the colonial government to institute the Moody Commission of Inquiry in 1944. The Moody Commission paved the way for the genesis of the welfare system in Mauritius and the birth of local democracy in rural Mauritius through the creation of village councils. We can also refer to some examples in other countries. In South Africa, a variant of the Commission of Inquiry was set up in 1996 after the end of apartheid. The Truth and Justice Commission of South Africa was a court-like restorative justice, set up by Nelson Mandela and chaired by Desmond Tutu. The commission invited witnesses who were identified as victims of gross human rights violations to give statements about their experiences and selected some for public hearings. Perpetrators of violence could also give testimony and request amnesty from both civil and criminal prosecution. The Institute for Justice and Reconciliation was established in 2000 as the successor organization of the Truth and Justice Commission of South Africa. In Australia, prompted by public outcry over the high number of indigenous deaths in custody during the 1980s, the Royal Commission into Aboriginal Death in Custody was set up. It investigated 99 cases between 1980 and 1989. While it found no evidence of unlawful killings, it highlighted systemic issues such as inadequate care and the impact of alcohol abuse. The Commission made 339 recommendations aimed at reducing indigenous incarceration and improving custodial conditions. Here again, we see the dialectical relations between historical social struggle and institutional commission of inquiry, resulting in social emancipation or human rights advancements. Madam Speaker, yes, commission of inquiries or boards of inquiry can be and have been used as tools against political opponents. While the primary purpose of such commissions is to investigate matters of public interest, and improve recommendations, they can be strategically manipulated to target and undermine political rivals. For instance, a commission might be established to investigate a particular matter, but its term of reference can be subtly designed to ensnare a specific political figure or party. The Commission's findings, regardless of their validity, can be used to damage the reputation or political standing of the target, even if there are no actual wrongdoing. Examples are numerous in many countries, and in Mauritius too. The latest two of such politically motivated commissions of inquiry in Mauritius being the Betamax Commission of Inquiry and the commissions of inquiry set up in the context of the institutional crisis, the tug of war under the previous regime between the presidency and the then Prime Minister. Madam Speaker, I support this bill for the following reasons. Many of the reasons have been highlighted by my colleagues and honorable members. The first one is the updating of an 80-year-old law. I'm very surprised to hear Honorable Adrien Duval saying that we must amend an 80-year-old law and not come with a new legislation. And this decontextualizes the evolution of constitutional evolution in Mauritius and laws in Mauritius. We cannot just take something dated 88 years and just plug in amendments like this. You decontextualize the law evolution. And it's very important to come with a new law because precisely the same inherent residual inconsistencies and clumsiness since the advent of independence and the Republic in 1992 needed to be addressed and cleared in law so as to leave no ambiguities, no misuse, as we have seen in the last wrangle under the previous regime between the presidency and the Prime Minister, event which occurred in 2018. First, let us mention that the Constitution, as my colleague mentioned, with the advent of the independence in 1968 and a republic in 1992, established clearly in Section 44 the clear line of demarcation of the Prime Minister and the exercise of President's function. And it is clear that Section 64, that no President of the Republic can act without the advice of the Cabinet, or, for that purpose, to Honorable Duval, or of a minister acting under the general authority of the Cabinet. And there's no one more important in the Cabinet than the Prime Minister itself. When Mauritius became a republic, various amendments of the Constitution, were brought to various pieces of legislation in Mauritius in 1991. The Commission of Inquiry Act 1944 was one of these legislations. There were 10 amendments brought to replace, 10 amendments brought to the Commission of Inquiry Act 1944 to replace wherever it appears the term Governor General with President. So, thus, the Commission of Inquiry Act 1944 started with the section 1.2, where it says the President may issue a commission into any matter relating to the public service, etc., etc. The President here in this section has only replaced Governor General. Okay, this was the amendment brought in 1991, just a few months before Mauritius became a republic in 1992. Thus, when reading the Commission of Inquiry Act 1944, separately, as rightly stated by my colleagues, from Section 64 of the Constitution, one can come to the erroneous conclusion that the President of the Republic can appoint a Commission of Inquiry. This was the erroneous reading which brought the constitutional crisis between the previous Prime Minister and the President of the Republic, of the then President of the Republic. And this is why I don't understand the reasoning of the Honorable Leader of the Opposition. Where was he in 2018 when when a general notice was published, General Notice 803 of 18 in the Government Gazette, which instituted a commission of inquiry for the purported appointment of a commission of inquiry by Mrs. Amina Garib Fakim, former President of the Republic, or on about the 16th March 2018. More precisely, to inquire on the circumstances relating to the non-compliance with the constitutional and legal provisions of the established administrative procedure applicable to the appointment of the above Commission of Inquiry. Where was the Leader of the Opposition? I don't know. Was he part of this decision to establish this Commission of Inquiry, where one of the terms of reference was precisely to inquire whether the power of the Cabinet and any person acting on behalf of the Cabinet? So, the present bill, now in the spirit of the Constitution, clarifies the legal framework to leave no ambiguities, no erroneous interpretation. It re-establishes in the law clearly the constitutional principle that the institution of a commission of inquiry is the prerogative of the executive, the cabinet, or a minister acting under the general authority of the cabinet. The bill, now in the spirit of the Constitution, confer clearly this power to the Prime Minister, who is, after all, the chief of the cabinet, the Prime Minister, and leader of the House. The bill leaves no ambiguity, no room as to who has the power to nominate a commission of inquiry. It spares us from the institutional crisis which bear the imprint of the previous regime. The previous regime did not dare draw the lessons of the previous dangerous constitutional crisis between the previous Prime Minister and the former President of the Republic. We dare. We are bringing the necessary amendments to with the new Public Inquiries Bill. Where they failed, we act. Yes. Madam Speaker, when I heard Honorable Duval saying that we must amend this, the 80-year-old legislation, I'm new to this assembly, but I cannot understand the reasoning of such a proposal. For me, it's like, colonially tainted proposal, To amend a piece of legislation date back 80 years, and during this period we had independence. During this period we had the Republic, we had evolution. I just cannot understand how these kind of, ideas still persist after independence and after Republic, after that death of the Republic in our country. Madam Speaker, in addition to addressing the legal issues we mentioned, the legal imbroglio, the new Public Inquiries Bill will be bringing at least 4. I will just mention it, my colleagues mentioned it, just for the record, bring at least 4 major qualitative leap forward. The bill opens the door for public access and scrutiny to proceedings of board and inquiry. This is clearly stated in Section 13 that the proceeding, that all reasonable steps as may be necessary should be taken to ensure that members of the public I record this one so that the chairperson can decide, this is new, to allow broadcasting of proceeding of an inquiry which may be made. And this is very important. In digital time, like we have public broadcasting of this parliament, we can have public broadcasting of public inquiries. And I think this is very novel in the piece of legislation. The second leap forward is putting the time bar for the completion of the Board of Inquiry, which was mentioned by many of my colleagues, okay? And it's mentioned in two sections, in Section 4 and Section 6. Section 4, the terms of reference of the Board of Inquiry. One of the terms of reference is to set the date by which the inquiry report shall be submitted. And Section 6, it's the duty to inform the Assembly where the Prime Minister proposed to set up the Commission of Inquiry. The Prime Minister has to state in the terms of reference the date by which the inquiry report shall be submitted. And the third leap forward is that it is mandatory to make public the report of the Board of Inquiry. This is mentioned in Section 21, laying of inquiry report before the Assembly, and it's mentioned in Section 22, the publication of inquiry report in the Gazette. This is very important, these two new clauses in the new bill. The fourth leap forward is a critical clause to protect the right of person likely to be prejudicially affected. This is mentioned in Section 18 of the bill. Madam Speaker, in conclusion, I would say that we live in 2025, that this debate, that this bill brings a wind of change in the country, like we've been doing for the last 5 months. And in the future, we do believe that debates should be held in the National Assembly, in the country, on the possibility to give members of the National Assembly the power to instigate commission of inquiries and their terms of reference by way of motion or otherwise as practiced in various democracies. In the meantime, I must say that Resistance and Alternative is proud to be part of the political forces bringing in this new law of public interest. As part of the Alliance du Changement and as a party strongly committed to public transparency, truth, and evidence-based political decision, we commend this bill to the House. Thank you, Madam Speaker.
Yes, Honourable Prime Minister.
Thank you, Madam Speaker. The current Commissions of Inquiry Act, as many orators have said, honourable members have said, dates back to 1944. I hardly can understand how Honourable Juval says we should keep that act and amend it. Its structure, its functioning are completely outdated and no longer provide an adequate response to the variable complexity of the matters that may in a modern society require the scrutiny of a statutory inquiry. First of all, let us, Madam Speaker, look at what the commissions of inquiries recently under the previous regime have come out with. When the former Justice of the Supreme Court, Mr. Lam Shanni, and his 2 members made a serious and sustained effort to reach the truth in connection with the social scourge of drug trafficking, which has increased vastly in recent years. His alarming findings and shocking conclusions, what happened to them? They disappeared into a void. The former government ignored most of its recommendations, and it cost the taxpayer 12 million rupees. Most of its recommendations were ignored. Similarly, when a public inquiry was set up to examine the conduct
of the former President of the Republic. It subsequently, the leader of the opposition was talking about trying to politicize things. It was subsequently appeared to have originated from an anonymous letter concocted in the Prime Minister's office by a special advisor of the Prime Minister, the then Prime Minister, who then promised to lay the letter before this House for scrutiny. It was predictably unfulfilled. That promise was never kept. No letter was ever deposed here in the Assembly. And it cost the taxpayer 10.5 million rupees. When the Commission of Inquiry into Horse Racing was set up in 2014, its preliminary report mysteriously disappeared after the general election of December 2014. And the interim report was, I think, tabled only in 2017, rather than government. But, Madam Speaker, not by the government, it was tabled by the then leader of the opposition, the Honourable Member's father, Zabeluk Juval. He is the one who tabled them. It was never tabled in front of the House. The Commission's findings and conclusions were submitted by the then President of the Republic, Mr. Kailash Prayag, to the then Prime Minister in March of 2015. I remember, purposely rang the then President to ask him to make sure that the Prime Minister gets the report, because it was an important report. It was about what was happening in the Mauritius Turf Club. The President told me that he has asked his rider to go and leave the report at the PMO. Question was put to the Prime Minister in Parliament, and without flinching an eye, he said he had never received the report. Disappeared completely. When international arbitrators awarded billions of rupees in damages against the reckless and irresponsible political scorched policy of the previous government in the Betamax case, dismissing the previous government case, the arbitration, for that politically motivated abuse and as lacking any shred of evidence. When the Privy Council dismissed with disdain the government's legal challenge to the award, and the independent DPP rejected the trumped-up police investigation for the bogus smoke screen it always was. What did the previous government do? Precisely what the leader of the opposition is complaining now, who was a member of the government, if I remember. And now he seems to be worried about exactly that. But this is what happened under the previous government. Let me give you a concrete example of how the previous government weaponized commissions of inquiries to settle political scores. The House may recall, we spoke about him this morning, how the now notorious Sattar Haji Abdullah, with the connivance of the former Prime Minister, together they tried to convince Mr. Dawood Rawat to get rid of the BIA group of companies for the symbolic sum of 1 rupee, with the promise that if he did this, the government would not harm him or his daughters. That was what was done. And Mr. Rawat, to his credit, categorically rejected this poisonous offer. And yet, I think, I can't remember, I think Honorable Utim mentioned it, the very same Sattar Haji Abdullah was appointed as an assessor of the Commission of Inquiry on the disposal of shares of the BI Company Limited. And also with the related, I think it was called Britam Holdings Limited in Kenya. If this was not a direct conflict of interest, what was it? What was the guarantee then under the previous Commission of Inquiry? What was happening then? Exactly what we want to prevent, actually. It is worth pointing out that one of the recommendations of the Commission of Inquiry, chaired by former Judge Duma, Bhushan Duma, was that criminal actions should be initiated against former Minister Roshi Badin for his malevolent acts in the sale of the shares of Britam Holdings Limited of Kenya. This is what Doma said. And what did Mr. Badin do? He swore an affidavit where he pointed out that one of the assessors, Mr. Sator Haji Abdullah, is a bosom friend of the former Prime Minister, and therefore he's judge and party in this case. And that was the end of the matter. Finish, forget it. In the drawer. And these three commissions, Madam Speaker, cost the taxpayer a total of 32.7 million rupees with no result to show. Nobody in the House had any idea what the Commission of Inquiry said or did. These Commission of Inquiries were set up for the wrong reasons, and their findings, their conclusions, their recommendations were completely ignored, left to sleep in the yellowing pages of newspapers and the dusty drawers of the administrative inertia. We have seen just such pattern for the last wasted decade. Inquiries have come and gone. They might as well have never happened. Let us come to the inquiry on Betamax, which we are being told was stopped on purpose by this same Mr. Badin. This is what he's been campaigning about. Let us look at the facts. The case went for arbitration in Singapore, presided by a UK former judge with high reputation. High reputation. The arbitrator stated, after having examined everything, that the allegations of fraud was completely unsubstantiated. There was no proof of any impropriety. Arbitration, if you look at the law, that should be the end of the matter. But no, the government then decided that the findings of the arbitration should be ruled out by the Supreme Court as it was against public policy. In spite of the fact, as I said, the International Arbitration Act said that an award should be final and the courts should not readily intervene. However, the Supreme Court intervened and cancelled the arbitration award. Betamax went to the Judicial Committee of the Privy Council to appeal. Look what the Privy Council said. The Privy Council said that the Supreme Court of Mauritius was not entitled to review the arbitrator's decision. The contract was not illegal. There was no impropriety. And it added that the Supreme Court cannot, under the guise of public policy, reopen issues that were settled. That's what the Privy Council said. Une claque magistrale à notre Cour suprême. That's what happened. And that should have been the end of the matter. The then government wanted to initiate, after that, after the Privy Council had pronounced itself, and not a commission of inquiry, as if as a fig leaf, I suppose, to disguise the slap they had just received after a final judgment of the Privy Council. I think Honourable Minister Utim rightly said, it is a contempt of court, that action. Du jamais vu. And they started a commission of inquiry. You know how many years after? It was 15 years, practically, after a commission of inquiry started. It was a sustained, dishonest campaign, a conspiracy at the highest level to manufacture evidence, especially against me, but also against Minister Beju. This was the purpose. The Honourable Juval should have looked at what his own father said at the Commission of Inquiry. I suppose you didn't look. It was, you were there, but then you didn't hear anything. You were there for nothing. Because you should see what he has said. Madam Speaker set up a public inquiry to cover the embarrassment after la claque qu'ils ont reçue. There was never the slightest basis for such an inquiry after the Privy Council had pronounced itself. It was, in fact, meant to find ways and means to taint our reputation with invidious charges. Nothing more. And it awarded, in awarding over $100 million against the state, which we had to pay. The taxpayer had paid. The distinguished independent international arbitrator scathingly dismissed the previous government's supposed justification as lacking even the semblance of plausibility. After thoroughly reviewing all evidence, the government had put forward, they found no basis to suggest that any impropriety whatsoever had occurred. As I said, these findings of the arbitrator were supported by no less a court than the Judicial Committee of the Privy Council, which decided that the previous government's case to be spurious and founded on elementary misconceptions of the law. In taking its decisions against Betamax, we all know, of course, Madam Speaker, that the previous government was assisted by legal geniuses, some of whom to this day no doubt continue to avert their legal services, their legal wisdom at considerable cost to their unsuspecting clients. They're still taking money out of people. But no cost will be ever as great as the cost to Mauritius of their reckless, politically motivated and foolish advice. Mr. Banner, all he has been talking about, he was instrumental in both the BAI Commission of Inquiry and also the Betamax one. And he's continuing to make unsubstantiated allegations during the campaign. As I say, you should have heard, if you were there, I don't know why you didn't hear it, what the former Deputy Prime Minister, Zabiolik Juval, said. He said he did not agree with that decision of Cabinet. He told Cabinet that this is a wrong decision. He was there at the beginning. He knows there was no impropriety and that it was going to cost us money. He even called in the then Solicitor General, Mr. Duran Debi, and asked him his opinion. And Mr. Duran Debi said to him that he was completely opposed to the cancelling of that contract and that the government will have to pay heavy damages if they do that. But, and they instituted the Commission of Inquiry. 15 years later, as Honorable Utim just said, it was a contempt of court. And it would have been challenged had there been this interference, as we think there would have been. They would have been challenged in front of the Privy Council again. Mr. Banner should be exposed, Madam Speaker, for what he is, like a vulture with a mixture of venom and ignorance. Ignorance. It's reprehensible beyond contempt what he's been doing. This is what SSR used to call a flash in the pan. Yes. He has been reduced to a political farce, political clown, I should say, ready to do anything to cling to even concrete for his survival. I know, Madam Speaker, you might say he's not in the House, but it is precisely because of this that I'm dragging him in here, to expose him. What a loudmouth demagogue he has been, dangerous demagogue. This is the background. This is the background of the Betamax case. The Mauritius public is now asked to support many more millions of rupees to be expended on a pointless public inquiry purely for political ends and because the previous government could not accept the responsibility of its own flagrant abuses. It has been proved. 2 judicial tribunals, including the highest in the Commonwealth, have denounced it. We know that the previous government didn't care about money. We heard this morning. They have brought this economy of our country to its knees. The House, Madam Speaker, has a duty to put an end to this long legacy of waste, self-enrichment, and abuse, which if we are left to continue, would cost again the hard-pressed taxpayer even more millions. This is what will have been the result. We all too plainly know that cynical exploitation and abuse of the state's resources, to which the government unhesitatingly resorted to whenever its political and personal interests required. When Monsieur Moustache leaks exposed their shame in all its nakedness for all the world to see, placing on show the tawdry, corrupt, and abusive nature of this criminal gang, which had seized and maintained control of the country by fraud and by lies. What was their first response? Yes, Madam Speaker. They said they announced a public inquiry into the leaks. Never. It never happened. There was never, even public inquiry was never started. It was just a show because the elections were there, people were revolting, so they said, well, inquiry. No inquiry was ever done. But the Mauritian people put this, what I could call a dying serpent, out of its misery, whose coils had wrapped themselves around the country, and at least to save the country public purse. And what has been the cost of all this? Tens of millions of rupees, as I said earlier, by the government on sterile exercises of political self-justification, not counting the time. We don't put the time of what the civil servants had put in, which properly accounted for even more tens of millions of rupees. Yet, not a single recommendation has been adopted. Not a line of any of the reporters debated in this chamber. Nobody knows what is in the commission of inquiry. No official government response. That shows, when I'm speaking, that in the hands of the previous government, there were no more than colorable devices again. They were never intended for the purposes for which public inquiries are supposed to exist, to cast light on social ills or public mischiefs, to establish the truth of tragic events, to apportion responsibility, and to lead to the diagnosis and remedy the causes. First, then, we will put an end to that shameful chapter and abusive inquiries of the previous government. Secondly, we will ensure that the conclusions and recommendations of the inquiry will not simply be ignored by future governments. They will have to be debated in this chamber. It never happened before. The government will have to publish a formal response, recommendation by recommendation to a report. Now, I heard Honorable Juval ask, it's a misconception. Complete misconception of the Constitution, of our system of government. We have a cabinet system of government here, not a presidential system. The president has to act on the advice of cabinet. And as I think Minister Suivez just said, who is the head of the cabinet? Who is the head of the cabinet? The Prime Minister, perhaps you don't know, meets the president every Thursday morning. It's in the Constitution. I have to keep the president informed. I meet him every Thursday morning. He's kept informed. When the bill, we propose a bill, he sees the bill. If he has anything to say, he says it. This is how the cabinet system of government works. And the determination of this government is to widen, to deepen, and strengthen our democracy. And in fact, I don't know where he's getting his quotations. In Canada, in the UK, this is the system. The UK had the same system, go and look, same system that we're putting here. The Public Inquiries Bill before the House provides for a legally robust framework in the conduct of public inquiries into matters of significant public importance. And it provides for the setting up of a board of inquiry with much wider powers than existed before. Events having caused public concern or capable of causing public concern. That also has to be taken into account, as well as where there is a public concern that a particular event may have happened. Sometimes it is like this. It will now fall under the scope of that new board of inquiry. The bill creates for more specific and detailed terms of reference. Additionally, and perhaps the Honorable Juval doesn't know, how do we decide the terms of reference? It's in cabinet that we decide the terms of reference, but that's how it is. The Prime Minister is in the cabinet, if you don't know. He heads the cabinet. This is how it is done. You're thinking of the kitchen cabinet, I think. That's what you're referring to. It's not the kitchen cabinet here. It's a real cabinet. It is. And the Prime Minister will now be possible to consult the chairperson or the proposed chairperson of the board before setting up the terms of reference, instead of just putting terms of reference, and you see the chairperson say, I don't like this, I don't like it. At least we'll have consultations, and he will be able to respond to these terms of reference. Furthermore, there shall be a statutory duty to inform the National Assembly. This is not the case with the actual Commission of Inquiry Act. We will have to inform when a board of inquiry has been or will be set up, the terms of reference will be seen in the National Assembly. You will see who shall be appointed as chairperson, and also whether the Prime Minister has appointed or proposes to appoint any other member. Additionally, and most importantly, in order to avoid the delays we have seen in the past with former commissioners of inquiry, there will now be a statutory duty to state the date by which the inquiry report must be submitted to the National Assembly. It cannot go on for years and years. That commission of inquiry on Betamax was 15 years ago. Now they were calling us to say, even your father said to the judge, "Madam, it's 15 years ago. How do you expect me to remember everything?" It's impossible. This will not be the case now. There will be a statutory duty to state the date by which the inquiry report will have to be submitted. Furthermore, in a spirit of transparency, while the Commissions of Inquiry Act provides an option as to whether the inquiry shall or shall not held in public, this one makes statutory provision for the Board of Inquiry to be held in public. Unless, for some reason, security reasons perhaps, the board decides otherwise. The new bill also makes provision for members of the public to be able to obtain or view a record of the evidence given and the documents produced or provided during the proceedings of the board inquiry. Your father complained. I also wanted. I wanted to know what other people have said so I can rebut the arguments. No, you can't have it. At the end, they said you can go in and look at it, all sorts of boxes of documents, and you have to do it within a few days. Not possible. What's the point of hiding it? We have seen how in the past, how many people have had their reputation damaged by their name being mentioned in the reports of the Commission of Inquiry they have to go to judicial review after that, where they could have done it there and then. We have seen how there have been no explanation sought from these persons, who then had to go to the Supreme Court through judicial review. I had to do it myself. And I won. On top of that, I won. Out of the 5 complaints I made, I won 4. On the 5th one, they said it was a balance. Maybe yes, maybe no. In a spirit of fairness, the Public Inquiries Bill makes provision for any person who, in his opinion or his or her opinion, the reputation is likely to be affected by public inquiry. They can be heard, they can be given evidence, they can produce documents, and they can see what has been said against them. According to the bill, the Prime Minister shall not later than 30 days after receiving the inquiry report, he will have to lay the copy in the National Assembly, on the table of the National Assembly. In other words, it will not disappear in a drawer. You will have a chance to look at it. Furthermore, the Board of Inquiry shall not later than 30 days after the submission of the report to the Prime Minister, publish it in the Government Gazette, so everybody can look at it. And there will be a new statutory duty on the government to respond to the report, not just laying it on the table. You can debate it. This doesn't mean that the government will be obliged to accept each and every one of the conclusions, but it will mean that the public will be able to see what the arguments were, what the government proposes to do about whatever mischief, and identified by the inquiry. These measures will also ensure that the work of the board will be conducted in a transparent manner and made accessible to the public at large. Honourable Tim rightly pointed out about this drug baron or drug peddler who had said he knows who in the government has been taking money from the drug barons for the elections. These have been thrown under the carpet. To conclude, Madam Speaker, let me reaffirm that the government today is honouring its commitment to provide clear parameters for the conduct of public inquiries, including, as I said, a strict time frame for such inquiries. We are repealing the Commissions of Inquiry Act and replacing it by modern, transparent, and comprehensive legislation. The government is taking steps to ensure that the purpose of the public inquiry purposes are generally fulfilled, not abused, like it had been done in the past, and the reports are not simply ignored. In fact, the reports were never known. Here you'll get a chance to see it, how much it has cost, and you can see the fairness, the independence and accountability of the whole process of this public inquiry. With the rights of everyone who might be affected by the findings of an inquiry report, they have a right to come and depose me. I have repeatedly said, Madam Speaker, that one of the imperative missions of this government is to restore integrity, pride and independence to the constitutional, democratic and civic institutions in which the freedom and strength of any nation principally resides. The bill contributes to that cause. Thank you, Madam Speaker.
Yes. Honourable Acting Attorney General.
Madam Speaker, I'd like to first and foremost thank all members who have spoken. I have listened very carefully to all the speeches and more so to that of the intervention of the Honourable Prime Minister just before me. I'd like to also thank right away, not at the end of my intervention, the officers of the Office of the Attorney General himself, who has put in a lot of effort in the work that he has produced. We are all very thankful to him, and I wish him a quick recovery. However, I'd like to add, I don't think I had to, but then I think sometimes it is necessary to underline important events. I mean, when I base myself on the intervention of the Honourable Leader of the Opposition and Honourable Adrien Duval, it's necessary for me to refer to the arbitral award, the final award in Singapore of the arbitration matter, the Singapore International Arbitration Centre between Betamax and the State Trading Corporation. Let me say here that this is dated the 5th of June 2017, and people will start to understand that when I read that particular document, the table of contents on issue 4, it is written at page 45, is the contract, the agreement Betamax had, including the arbitration agreement, illegal. That was a question that the arbitrators had to answer. Is it illegal and unenforceable? This is one of the main issues that they had to cover. So I say that today because Honourable Duval said that these are issues that were not covered. Let us say that he is wrong there. I say that respectfully. It was covered. I took it upon myself not to just come up with statements, but I went through the award to make sure that what I'm saying, I have verified it, counted, checked it, and I'm therefore convinced that what Honourable Duval is saying is not right. So let me also say that maybe if he's missed that part, I'm sure he's also missed the other part, and I say it sans hésitation. One of the lawyers who participated in this whole scandalous process, Ravindra Chetty, senior counsel. He was the one, strangely enough, representing some elements of the kitchen in those days. Anyway, Kalchul, Bartan, we call it, Bartan. So then, when I read at this particular issue at page 46, is it illegal? And I'm going to read parts of what the arbitrators said. Paragraph 170. The tribunal has found that STC has failed to discharge its burden of proving that the agreement was agreed as part of a conspiracy to commit an unlawful act under either interpretation. The tribunal has found that the PPA was not breached. I can go on, and I will. This tribunal, at paragraph 182, this tribunal rejects the submissions of the STC. Specifically, the tribunal does not find Mr. Bunjan gave evidence that was untrue in his first statement or at all. This explanation is plausible, 184, and entirely consistent with Mr. Bunjan's first witness statement. Having found that Mr. Bunjan was not untruthful as alleged by the STC. Let's pause. As alleged by the STC. Allegedly, Mr. Bunjan was lying, only to satisfy the head cooks of that kitchen. That allegation cannot provide a basis for the tribunal to draw the inference alleged. Madam Speaker, you know upon what the STC caused losses to the coffers of this country, taxpayers' money to be paid? On inferences to satisfy the head cooks of the day. And you know what is shocking? The Honorable Prime Minister referred to one of the Suivez who was helping to, to cook away. Then he was Minister, Honorable Badin. Wasn't he part and parcel of this whole mess? So it is when he was part and parcel of this whole mess, having brought an end to the agreement, it caused losses to the country. It caused losses in billions to the country. Billions! And we have the representative honorable member of the PMSD holding on to the remnants of a colonial era. The representative in Parliament and National Assembly in 2025 is still holding on to the colonial law of 1944. At least they're consistent. But then, what about the honourable member of the MSM? They are holding on to this law, I'm sure they don't know why. Only because they want to satisfy the ego of the head cook. That is all.
Excellent.
No, I'm sure he's still cooking away. Huh? 8-4. And look at what I say again. Paragraph 195. Again, I quote, again, STC invites the tribunal to infer on the basis that government had therefore ultimately agreed to a commitment that ran counter to its earlier stipulations, that the agreement was an illegitimate transaction. However, it is more plausible that this change was simply the product of the parties' protracted commercial negotiations. The tribunal also rejects these submissions. Under the chapter of the SLO's advice, paragraph 200, the tribunal therefore finds that these allegations are incapable of grounding any inference that there was a criminal conspiracy between Mr. Bunjan and members of the then government. So, when I read all this, paragraph 207, in any event, these difficulties could not support an inference of criminal conspiracy. And I read paragraph 211D. STC led no evidence, and for members out here to listen and members of the public to hear, STC, fomenté par le gouvernement du jour, poussé par le leader du Reform Party, qui était lui-même chef de la cuisine. STC led no evidence from any person who could have given direct evidence of a conspiracy. Therefore, based upon what are members of this opposition telling us, let us hold on to the laws of the colonial days? Let us not change the law, let us simply amend it. Amend what? Amend what? Amend this way of trying to run the affairs of the country based on simple inferences, allegations that could not even be substantiated, Madam Speaker. And the taxpayers ont dû payer plus que 6 milliards de roupies. Qui alors va rembourser ça aux taxpayers? Today we are in difficulty. And they dare come and tell us we should pay up, pay out, and keep on our promises. Today we are having those difficulties because of such mess that has driven this country to the ground. And then let me look at this. Paragraph E. On a related point, I quote, in its closing submissions, STC listed a number of people, who it submits have been subject to criminal or provisional criminal charges for their roles in the allocation and eventual signing of the agreement. STC did not, however, offer any public specific allegations as to what those roles might have been and when and how the conspiracy was alleged to have been entered into. So back in the day, you do not manage to have any witness, any evidence, no substantiated allegations. So shouldn't the MSM be condemned for this disaster? Oh no! They stand here at the decorum of the National Assembly. Madam Speaker, let us not change the law. Let's leave it the same. To answer to Honorable Juval that talked about, allegedly, he thinks that the Prime Minister will decide one day he wakes up, okay, I want an inquiry. This is not how it works. I'm sorry. Read section 61 of the Constitution, because you know, you can, maybe, you see, the Honorable Prime Minister is right. He is, and I understand, you know, I mean, obviously, you know, when you rub shoulders with people who behave in such a manner. Quand on fréquente lycée, on gagne peace. You know? So when you, I mean, put it in English, when you go close to those dogs who have fleas, you start itching. You know? And this is what happens. But what I humbly suggest the Honorable Juval to do, before rubbing shoulders with dog-infested fleas, you know, what you should do is come and take some sort of medication to get rid of the fleas. You know what is the best medication? The Constitution of Mauritius. You know what the Constitution says? There is a chapter called Cabinet, if my young member is not aware. Section 61(2). The functions of the Cabinet shall be to advise the President in the government of Mauritius. And, you know, don't stop there. You're already drawing conclusions. Hold on, hold your horses. Get away from the dog with fleas. Hold on. And the Cabinet shall be collectively responsible to the Assembly. And I go on. For any advice given to the President by or under the general authority of the Cabinet, and for all things done or under the authority of any minister in execution of his office. So let us not forget, whatever the Prime Minister will be lawfully entitled to do, the Cabinet will be collectively responsible for it, because the Constitution says he is doing so under the authority of his power. This is how Cabinet works. Back in the day, there was a so-called Prime Minister who did not believe in this type of democracy. That is why I know he's very ill at ease right now, sitting next to the MSM. I know, when I look at some of his questions, when I try to understand how he tries to demarcate himself. Don't be afraid. Embrace the truth. This is what I say. We cannot keep on sticking to the old days of 1944. Let us evolve. Young men, let us move forward. We have promised change. This is change, Madam Speaker, and change there is. We have to adopt our changes, and what he should do is at least congratulate. He tried to do it timidly, but please, Section 61 explains all. I shall not say more. Let me say that once again I commend the bill to the House.
I need someone to second this bill. Yes. Thank you. The question is that the public inquiries. All right, I'll start again. The question is that the Public Inquiries Bill, number 5 of 2025, be read a second time. Those in favour say aye. Those against say no. The ayes have it.
Public Bills Committee stage.
Yes.
Clause 1, short title. Clause 2, interpretation. Clause 3, setting up of Board of Inquiry. Clause 4, terms of reference of Board of Inquiry. Clause 5, no determination of civil or criminal liability. Clause 6, duty to inform Assembly. Clause 7, suspension of inquiry. Clause 8, composition of Board of Inquiry. Clause 9, term of office of members. Clause 10, secretary to Board of Inquiry.
The question is that clauses 1 to 10 stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it.
Clause 11, technical advisors and experts. Clause 12, rules of proceedings. Clause 13, public access to proceedings. Clause 14, restrictions on public access. Clause 15, law of evidence to apply. Clause 16, appearance of law practitioner. Clause 17, powers of examination. Clause 18, persons likely to be prejudicially affected to be heard. Clause 19, division of opinion among members. Clause 20, submission of inquiry report.
The question is that clauses 11 to 20 stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it.
Clause 21, laying of inquiry report before Assembly. Clause 22, publication of inquiry report in Gazette. Clause 23, immunity from suit. Clause 24, protection of witnesses. Clause 25, remuneration and inquiry expenses. Clause 26, no cost against member. Clause 27, duties of police officers. Clause 28, offences. Clause 29, criminal proceedings. Clause 30, judicial review. Clause 31, regulations. Clause 32, repeal. Clause 33, commencement.
The question is that clauses 21 to 33 stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it.
The first schedule.
The question is that the first schedule stands part of the bill. Those in favour say aye. Those against say no.
The second schedule.
Question is that the second schedule stand part of the bill. Those in favour say aye. Those against say no.
The third schedule.
The ayes have it.
The third schedule.
The question is that the third schedule stands part of the bill. Those in favour say aye. Those against say no. The ayes have it.
Title and enacting clause.
Question is that the title and enacting clause stand part of the bill. Those in favour say aye. Those against say no. The ayes have it. The question is that I do report to the House that the Public Inquiries Bill number 5 of 2025 has passed the committee stage without amendment. Those in favour say aye. Aye. Those against say no. The ayes have it. I will now resume my chair. You may resume your seats. Thank you. Honourable members, I have to report to the House that the Public Inquiries Bill number 5 of 2025 has passed the committee stage without amendment.
Public bills, third reading.
Madam Speaker, I beg to move that the Public Inquiries Bill number 5 of 2025 be read a third time and passed.
The motion needs to be seconded. Yes, Honourable Dr. Boulel, yes. The question is that the Public Inquiries Bill number 5 of 2025 be read the third time and passed. Those in favour say aye. Aye. Those against say no. The ayes have it. Honourable Prime Minister, adjournment.
Madam Speaker, I beg to move for the adjournment of the House to Tuesday, the 13th of May at 11:30 a.m.
The House stands adjourned. We have adjournment matters. Yes, Mr. Francois.
Thank you, Madam Speaker. My request is addressed to the Honourable Minister responsible for shipping. It is about the many defective containers sealed with tape that are used to transport products to rigs, such as animal feeds, rice, flowers, and other commodities. I'm informed that importers' consignments deliveries are regularly damaged by rain and seawater without any compensation in return, causing loss to them. In that regard, may I humbly appeal to the Honourable Minister to intervene with the Mauritius Shipping to see with the container service provider company for urgent remedial measures for the replacement of these old and damaged containers, as we don't want to see again the episode of Jirigation Puri, ou manger des animaux gâtés to land on the market in Oryx. Further, may I request the Honourable Minister to also look into the asphalting and upgrading of part of the muddy and dusty and third tarmac of the new container park depot for a convenient, reliable storage and handling of solutions and environment at Merus. Thank you.
Yes, Minister.
Thank you very much, Madam Speaker. I'm glad that my good friend, Honourable François, gave me notice of the issue that he has raised. He can rest assured that we press upon the Mauritius Shipping Corporation to take corrective measures to address the situation. So he can rest assured things are done.
Thank you, Minister. Yes, Mr. Bishop.
Thank you, Madam Speaker. My request is addressed to the Honourable Minister of Education and Human Resources. Given that there is a serious skills mismatch in Mauritius, in this spirit, will the Honourable Minister consider running skilling and reskilling programs in government schools after school hours? Thank you.
Yes, Minister.
I've taken good note of the Honourable Member's request, and the answer is yes. The Human Resource Department, especially HRDC, is going to look into that.
Thank you. Very good news. Yes. Yes, Mr. Bichuk.
Madam, I have a request to the Honourable Minister of Land and Housing concerning the social housing income threshold, which is currently of 40,000 rupees for one applicant, be one single person or a family. So it raises a question of inequality or fairness, because very often I come up with two situations whereby people who had applied some 15 to 20 years before are being called for an interview today, and today their income has crossed 40,000. And secondly, I find that this, the current income threshold favors single applicants more than families, because someone who is single and earning 40,000 is not equivalent to a family who is whereby husband and wife are earning 40,000 rupees. Thank you.
Madam Speaker, I believe that the issue that the Honourable Member raises is a very valid point. It has already been addressed by myself with the officers of the NHDC and the NSLD, who have submitted a report and analysis. It has clearly shown that there has been an increase also of income over the various increases yearly, even recently in January, and therefore it brings them out or slightly above the 40,000. And then a lot of them are caught in the income trap. We have made representations to the Ministry of Finance, and I can rest assured, you can rest assured that we will be looking into the matter. Government will come up with a solution in the forthcoming days or weeks. Thank you.
Thank you. Yes.
Madam Speaker, may I request our Honourable Minister of Health to do a site visit at SSRN Hospital behind the pharmacy. We have a huge unused space, a room which is renovated, new, which can be used for a transition ward for patients being discharged from the hospital. Thank you.
I take note of his request and I'll do the necessary.
Thank you very much. I think we're done. Thank you very much, everybody.